Hello and welcome to Entrepreneur Empowered. I'm your host, Attorney Sid Pedinti, aka the Entrepreneur's Attorney. I welcome you here. If you're tuned in for the first time, we're going to cover in the next 40 to 60 minutes different business, legal, intellectual property strategies that we've been talking about for the past couple of weeks. And if you're already a listener, I welcome you here again. Today in the show, we have a few questions that I want to answer. We have a question from Terry from Georgia, who asked us, how much does it cost to trademark something? Then we have Norma from Miami, who asked us, can you create an invention without a patent? And lastly, we have Sherry from New York, who asked a copyright question, and when can I copyright a song? And once I die, how long does my copyright last? Well, these are very interesting questions, and today I'm going to help you get some answers regarding these exact questions, as well as give you a few more details about how trademarks work from a state versus a federal perspective. Well, and before that, what a trademark is, how to conduct a preliminary search for a trademark, ensuring you have a mark that you're using that's not infringing upon somebody else's trademark, as well as how to identify a classification for the particular good or service that you're looking to trademark, right? So when I talk about classification, the trademark database is broken down by industry and what specific good or product that particular trademark falls under. So there's a lot of different categories, and you want to be very specific because that's the industry, and how you use it is where your mark will be protected. Okay, and also we're going to talk about how much a trademark will cost you, and lastly, what can you trademark, right? Which is very important. So I have put together my information here. If you have other questions as I'm talking through some of these concepts today that maybe I'll talk over a little fast, or I may skip over, or you may still have questions because you're not able to follow some of the concepts I'm describing to you in detail, feel free to get back in touch with me. My law firm website is californialawservices.com. Once again, that's californialawservices.com. You can go to the contact us section. I have a form I have inserted it on there, so that if you have any specific questions regarding the topics today or any of the other topics we've been talking about for the past 6 to 7 weeks, I welcome you to go ahead and type in your question. If it's something that I don't know or I don't practice as part of my daily services in my law firm, I'll do some research about it, discover the answer for you, and answer it on the show, or I may even bring in a subject matter expert who we can dial into and get the answers that you're looking for. Okay, so with that said, let's jump right into trademarks. What I'm going to do today is share a few screens with you, if you're watching this on video, and help you identify some of these resources. Now, if you're tuned in on Bashani Radio or iHeartRadio or one of the other audio resources and you're listening to us via podcast, then I will make sure that I can spell these out for you so that you have these websites at your disposal and you have a step-by-step system to follow. Now, once again, I'm going to give you my telephone number. In case you want to send me a text message, I'll be more than happy to send you a direct link to this document that I'm creating for you with the resources that I'll paste here. I'll be more than happy to send that to you so you can use it. My phone number is 213-924-3466. Make sure you send me your name, what city you're from, what specific question you have regarding business, legal, intellectual property strategies, and I'll be more than happy to send you a link to this specific format that we're going to talk about today. Okay, so let's dive right into it. So first of all, let's start with what a trademark is. And Terry, in order to help you understand a bit better into trademarks, what I'm going to do is go through some of the definitions that I've listed here. You can find this on my website, californialawservices.com, under the section titled IP Law, which stands for Intellectual Property Law. Okay, so simply put, a trademark is a word, a phrase, a design, or even a symbol, or maybe a combination of them, that identifies the source of the good to the business who's using it commercially. Okay, so in other words, you are telling the marketplace, you're describing in the marketplace who you are, what goods and services you create and you publicize, and the consumers know who the creator of that particular good or product is. There is something called service mark, which you get the SM symbol, which is the same as a trademark. And now in common law, which is if you don't register your trademark, I still encourage you to use the little TM symbol after you've done your research to give at least geographic notice for the people who you're directly interacting with right now or your competitors in your geographic area. Okay, so service mark applies the same way and identifies a particular service that's been provided by a particular brand. Now, to get your trademark approved, now when I talk about approved, I'm talking about two specific systems. There is a common law trademark which does not require any specific filing with any entity, right? This is something you can use right away as soon as you've created your business name, your brand name, or even a product or service name, or perhaps even if you have a software and you've created a name for your platform, think about protecting it, at least as you're building this out, as you're picking up momentum, as you're gaining stability and popularity in the marketplace. Think about protecting that with the TM symbol right above or below the logo, right, or below your name. And that the same concept goes for logos. You want to make sure it's on there so you're giving notice. So that's the first system where you are using this, you're advertising your business, you're in the course of trade, and you're actively publicizing this name or goods name or brand name. The second is registration with United States United States Patent and Trademark Office, USPTO. Sorry about that. So there's an art and science, if you haven't already discovered, to creating a high impact, easily memorable brand name. Okay, so the first thing you want to do is start doing some research to make sure that your particular brand name is not taken. Here are a few pointers I'm going to give you right now. And so, when you think about trademark application again and getting it approved, these pointers come really in handy because we're talking about the federal registration system, which is governed by the USPTO, United States Patent and Trademark Office. So think about creating a name that is unique, perhaps even abstract, non-descriptive in nature, where you're not simply describing the particular good or product itself and trying to trademark the name, where it's not something obvious, right? So think about Google, Yelp, these kind of names, which have no meaning. This is not, or simply a variation of another mark. So, you're not creating Star Ducks out of Starbucks, or so to speak, right? Or something that's not geographic in nature in particular. So these are some pointers. Also think about, creating something that is not just a mere translation or description of your good or product or your brand from another language. So just, calling it by some other language does not automatically give you a trademark on it. And most importantly, it's not something that's already being used in the industry by competitors, right? So these are things you want to think about. These are certain elements and components that you want to work on, and from your side, as part of your due diligence, to ensure you are following industry best practices, you're not infringing on somebody else's intellectual property rights. And the last thing you want to be in is in a position where you are obtaining contracts, you're publicizing your business, you're gaining momentum, only to discover that the name you created is somebody else's trademark, right? And now you've received a notice from them. So That's a really bad position to be in. You don't want to be in that position. So these are some pointers that I've just given you. Try to keep it unique, try to keep it abstract, try to be non-descriptive in nature, non-obvious. Make sure it's not just a slight variation of somebody else's mark, right? Like taking out a letter, for example, from somebody else's name. It's non-geographic in nature, not simply a translation. And lastly, and most importantly, that it's not already being used in the industry as part of a name or a phrase or a concept of somebody else. So the first step, once you've come up with this name or as part of your research process, what you want to do is there's a few resources that you probably want to go and spend a little bit of time researching. Okay, and I've broken this process down for you a little bit further. So let's go ahead and explore why it's important to file a trademark. Number one, and so when I talk about filing, I'm talking about registration of a trademark with the USPTO as opposed to using the common law trademark, right? The TM sign, not actually registering it, but going ahead and using the common law protection that is of avail to you. Number one, you give notice across the entire U.S. and in some cases, the U.S. also has treatises in place with other countries which recognize the trade names, and so you have automatic protection in those countries as well as part of these different conventions that the United States is involved in. So keep in mind, giving federal registration, acquiring that intellectual property stamp from the USPTO has international recognition in many aspects. Okay, so apart from that, you're giving notice to your competitors as well as the world at large in the United States, right? Even if, as I just mentioned, even if you're internationally registered, that you're operating under a certain name, you can be using a specific logo, a catchphrase, and these restrictions grant you exclusive rights as to your name and logo in these markets. Okay, so you're able to cover a much larger territory and protect your business name, your identity, your unique identifiers across the U.S. in the different territories, as well as based on the specific conventions that the United States is a part of in those respective countries as well. Okay, so the protection aspect to it is absolutely the most important. You want to make sure your brand is not being confused with somebody else who has the same name, logo, or probably offer similar range of products or services, right? This is important because it preserves the goodwill and the reputation that you have in the market. And this is everything in terms of gaining clients, building trustworthiness in the market, as well as being recognizable. If you're watching this video, you'll see the little pop-up here that popped up. I'm having a conference in half an hour where we're going to talk about the exact same strategy. So that's how long we have for the rest of the video. So I'm going to try and speed through this as much as possible and give you everything you need. Like I said, if there's any questions or if you'd like to obtain a copy of all these different resources that I'm walking through, feel free to go onto my website, send me a quick note, and I'll make sure I do that, okay? And you can find that here, californialawservice.com. The next thing that trademarks allow you is specific rights. It grants you the right to pursue affirmative action against parties who use your brand, trademark name, without the right authority, right, or paying you a licensing fee. So that's very powerful. This is a way to control, perhaps even quash competitors, right? So although you do not need to register a trademark to acquire protection or bring suit, as I just mentioned, and in the case of a common law trademark, this may weigh in heavily to help you against infringement suits. So if you're in a position where you have a lot of momentum, and if you're in the unfortunate situation where you're a party to an infringement suit, a trademark infringement suit, which can, turn quite ugly, then the federal registration definitely comes to aid. That's a weapon that you could use in the lawsuit, which has a lot of value. So definitely think about that as you consider whether you're going to register a trademark or use the common law trademark. Lastly, we have value, right? It enhances the value of your brand. It preserves the value of your brand as you enter into partnerships, joint ventures, or even if you're looking to exit. So if you're planning to sell your company, then preserving your brand name, your trademark, goes a long way. Okay, so think about this as you're in this process. When you're creating your business, think about it from a larger picture and think about how you want to create a brand as opposed to a business, right? And so approach it from that aspect. Your investment into acquiring a trademark is something that gives direct value. It derives immediate value into your business, raises your net worth, and allows you different tools that which you can control competitor behavior from. Um, Here is a quick breakdown I've given you on how to go about getting the trademark. So what I'm going to do is brainstorm real quick about these ideas, and then I have different windows open here which I'm going to share with you on the different resources that you could use right away. And I'll give you an example of a company that I just opened which I was thinking of getting a trademark for. And I'll perhaps use that as an example here to demonstrate how to conduct a trademark search, okay? Excuse me. All right. The first step, of course, is to really break down your particular trademark or even patent or even in a copyright situation, right? Really understand and break down, analyze, do some research about the proposed patent or the trademark or even copyright to figure out if it's in use, right? If your business can actually use this develop this particular intellectual property and then use it and monetize it in different ways. So start from a Google search, right? Do a comprehensive search of your name, of your idea, of your logo, of the different catchphrases you have, perhaps even the website URLs, right? Or maybe even picking up from content. Now, let's go here to the first resource. So as I mentioned, Google is generally perhaps a good place to start. Let's go with this example of a company that I was thinking of creating, right? Let's call it Bullseye AI. It's an idea for a technology-based AI incubator. So let's go with that name and explore how that concept will work. So as I'm walking through this Bullseye AI, right away it looks like at first glance there's nobody with that name. I may go to images to see if there's any particular logos. I know the Target logo with the bullseye comes up, but it's quite a different industry, and the way they have used that is quite different from my intention here. So can I use the Target logo in this case, something like this? I would obviously stay away from that. This is a registered mark that Target has for this particular logo design or theme. So as I'm developing a logo for my Bullseye AI company, I would think of a slightly different theme that would not infringe Trademark's existing logo. Okay, so maybe Target Bullseye of some sort. So that's right off the bat. I know as a warning that using something existing from Target, even if it's anything similar to this, would be a bad idea for me. It's setting myself up for a potential lawsuit, even if it's something that's unrelated. It's something I'd like to avoid. So there's a quick red flag for you. Second thing you want to do is go to the USPTO, the United States Patent and Trademark Office. Their website is www.uspto.gov. So I'm going to go ahead and click on that. As you enter the USPTO website, you'll notice quite a few different options. What you want to do if you're looking for trademarks and trying to discover whether or not there's a trademark in your particular name, you want to either hit the trademark button up here or scroll down on the first page and you'll see what is called a trademark database. It is called the Trademark Electronic Search System, or also called TESS. Okay, so you want to go ahead and hit that button and you will be directed to a link for the trademark page. If you scroll halfway through the page, you'll notice there are a few different options for you here. So on the same page you have the electronic trademark system, which is called TESS. So if you want to hit that, you'll be directed into the trademark search database. You have a design search code as well, based on specific elements of a design or a mark. Okay, so here you have access to these design codes, understanding what they stands for. So as I mentioned earlier, these are the different classifications available, and a guide into by the PTO on how to recognize some of these particular categories, right, as far as distinctions and similarities are concerned. For our purposes, in terms of the trademark, we want to go directly into the TESS system. Once you're on here, you have three separate options. You can browse by the word, you can browse by the word and or a design mark, right? The structure, as you see here, it says structured. It's a bit more specific, where you have more options in terms of attorney on record, coordinated dates, cancellations, the description of the mark, the particular design codes, distinctness element. You have translation. So as you notice here, there's a whole bunch of options that you do have. You also have two other fields where you can look up alternate trademark names and logos as you're navigating the system here. The other more common way to look at this is what is called the free form lookup, where they give you more autonomy in terms of your search queries, as well as figuring out how you want to go ahead and structure the search. So these are the three basic options offered. Once again, it's a basic mark search, so by the word itself. The second is a design mark, so here we're looking at logos in combination with the actual name. And the third one we're talking about is a more structured way to do that. So for our purposes here, and to answer Terry's question, what we want to do is figure out the classification of your particular trademark. So based on the industry you're operating in, based on the market you'd like to compete in, and perhaps even looking up if your direct competitors in your market have existing trademarks. So, you haven't given me much information to help you out in this process, but this is something you can do by yourself, where you go to these different resources. Once again, the Trademark Electronic Search System is probably your first starting place. There's a link here once you go to the site that you'll see the USPTO has given guidelines into what a confusing mark could be. All right, so this is fairly extensive. This is a short version of it. You can go back to the trademark database and look for it, where they have an extensive version of that, which gives you the slight variations of what could be considered strikingly similar, right? Or confusion, something that would cause confusion in the marketplace. So as far as possible, you want to try and avoid something that looks strikingly similar, or even anything to do with what your competitors in that space are using, right? That's the way to be distinguishable as well as memorable. So go ahead and do your basic search. So if I'm going to say Bullseye AI, that's the combination I just gave you. I'm going to hit a submit query here. It looks like there's no records found, indicating, at least from a first glance, that no one's using that particular trademark name. What I'm going to do is go ahead and look at all three of them. So here it auto submitted my data. And I submitted that, and it looks like, again, there's nobody using that particular word. Let's try one more time. And in this particular one, it gave me back a few results. So as you see here, the three database systems are slightly different in terms of the data they retrieve for you. The third one is a much broader search, giving you relevant words which has anything to do with this. If I'm going to go ahead and hit search here, I'm going to try and identify if there's any particular ones, and there's nothing that came back, indicating to me, once again, that that particular word may in fact be open to use. The next thing we want to do is go to a domain hosting website like GoDaddy or 101 domains. There's plenty of them. And figure out if someone's actually taken this particular name. So here I am looking for, once again, bullseyeai.com. It looks like that one is open. I'm going to try another domain search. I just did that in GoDaddy, and as you notice that it was available. The next one I'm going to go to is 101domain.com, and let's go ahead and see if I can submit that search here. Bullseye.ai. And as you notice here, this domain as well is open to use. Once again, indicative of the fact that it's open for my use as a brand name if I need it. The next thing I want to do, and what I would suggest you do, is to go and search your local business Secretary of State business page and do a business entity name search. So it's either corporation, LLC, or perhaps a numbered company. So here, once again, I live in California, so I pulled up the business directory of the Secretary of State of California. If I go in and do a Bullseye AI search here in the corporate name, nothing popped up. If I now change that to an LLP/LLC name, let's see if something else comes up. Once again, negative results. Lastly, as an entity, of course, I don't have an entity name or number, so that search is clear. This shows me from 3 layers that that name might be something I can trademark, I can use in the course of my business, I can name it a product, I can make guidelines out of it, I can name it my brand name itself, if I develop a software company, Bullseye AI, and create a brand out of it. So hopefully that has given you a little bit of direction and guidance in terms of how to navigate the Secretary of State website, the trademark database, how to do some of the searching on Google, as well as the different USPTO and TESS tests, the Trademark Electronic Search System, to figure out whether or not you can acquire your trademark. Now, if you do pop into a situation where there's somebody using your name, again, that's a whole different ball game. It's something I'm not going to dive into today's particular video. But keep in mind, if somebody has a registered trademark that is quote-unquote strikingly similar, or even gives a rise of confusion, then you want to try and stay away from that as much as possible. Okay, again, if somebody is using your particular domain name as part of their trademark, again, that's a confusing situation, right? So try and be as, like I said, unique, random, arbitrary as possible so that there's really no likelihood of confusion, which is the biggest reason why trademarks get denied by the USPTO, why they're not granted. Okay, so hopefully that gives you a little bit of direction, like I said earlier, into navigating the system. It is easy once you understand it, but at every layer there's complications, and whether you're doing this for the first time or you've done this hundreds of times, just like anything else, you have to be methodical, structured, as well as very organized in this trademark development and procurement process, right? It is tricky. It can get real expensive based on what you have in mind, which is the next topic I'm going to talk about briefly here. What is the cost of getting a trademark? Once again, if you go to the uspto.gov and go into trademark fees, you'll see here a variety of links where you can apply online as well as in person, or by mail you can send it in. The trademark application form, there's 3 different classes that are given here. The first is the TEAS, the trademark application form, the plus assist form. Okay, so for that it's $225. That's the cost of acquiring that. Remember, it's per class of good or service. Excuse me. Okay, so for every different category you're looking for, and if I go here, let me pull up the list for you so you can take a look. So these are all the different categories. There's different classes. There's a description of which specific ones they are. You can keep going down the list. There's a whole bunch of them right here. As of now, on the USPTO website, you'll find 45 different classes, the different explanations, as well as what they do in particular contain and what they don't contain. Right, so you want to make sure you go through each and every one of these because it's very technical. Filing the wrong category under the wrong class will get your trademark application denied. You are not going to get a refund from the USPTO, and this may in fact prohibit you from using that name. Right, if you're already in the course of business using the name, if you have contracts that have been executed with that name, especially if the brand name which is the trademark that you're looking to get, then you want to be very careful doing that. You want to make sure you do this ahead of time where there's no conflicts. You don't have to stop business just to fix the trademark issues, okay, because of a wrong filing. So can you do this yourself? Of course. This is designed for individuals to be able to go on there. It's a little complicated, right, at first, and can be overwhelming because of all the information found here on the USPTO page. However, take the time to go through this methodically, like I said, make some notes on it, compare the different structures available to you. There's a regular form that you can fill out and mail in with all the supporting documents. It's $400 for the application. As you can imagine, the USPTO get millions of these applications. I think it's now in the millions, and you want to make sure that you have all the information in a clear, structured, presented way where they're not going to deny this application. Okay, so the second one is a TEAS reduced form, which is a $275 per application per class or good. So for example, if you have a software name, I just gave you the example of a Bullseye AI. If I'm looking to trademark that name in the legal industry and the real estate industry, as well as the medical industry, and let's say the construction industry, okay, so 4 different industries, we're talking about 4 classifications. And in addition, if I want to make that a software product as well as get trademark protection from an educational standpoint, and let's say from a coaching and presentation workshop standpoint. So now we're talking about 7 different categories and classes of goods and services that one product, my software company Bullseye AI, a hypothetical name that I just came up with, is potentially going to get trademark protection. So as you can imagine, that application now all of a sudden has cost you $1,500 from $225, right? So based on what your particular business need and your industry is, you want to be very careful in what you apply. Keep in mind you are not going to get a refund from the USPTO, and if your application is not complete, where there is missing information, once again, the examiner who's going to examine why they should grant you this trademark will reply back to you with a ton of questions that you have to correspond and reply back in a very timely manner. So, long story short, as you can imagine what I'm just telling you, trademark laws are complicated. Filing a trademark may seem simple. You may have come across entrepreneurs who do this themselves, which is great, but if you're not really sure about how to do this, please go ahead, get the assistance of an attorney, do more research by yourself, identify these things before you go ahead and start filing these trademarks. Okay? So that's the long navigation of the trademark process. Terry, I hope I've answered your questions into each and every one of these. Again, there's a state trademark database where you can file your trademark, as well as a federal one. I recommend you get the federal one. That way you're protecting your business all across the U.S. What to search for, I've showed you this on Google. I've showed you this on the different domain databases, as well as on the trademark website. How to identify your classification of goods and services. Once again, I've briefly touched upon this topic. It's based on the specific products or services and the industries you're looking to enter. How much does it cost? There's different cost structures based on what you're looking to file. And what can you trademark? Well, you can trademark a logo, a name, a symbol, a catchphrase, even a smell. Okay? Even smells can be trademarked if it's a unique identifier in the marketplace. So that's the short guide on how to register a trademark. Let me go ahead and answer 2 more questions here before I jump out. We have Norma from Miami who has a question. Can you create an invention without a patent? Norma, of course, right? Patents are the legal protectionary measure given to an invention that is novel, that is non-obvious, that has a specific utility function or design aspect to it. So it's like, there's the analogy of the chicken or the egg, right? Do you create and spend your resources in obtaining a patent, or do you do it for the invention itself, building a prototype, taking that to market, testing it? It's a complicated question, right? Based on your resources, which I'm guessing are not unlimited like the big companies, you may have to design a prototype, get a functional working model, and then spend money on obtaining the actual patent process, right? The actual patent itself, with, once again, it's the USPTO, United States Patent and Trademark Office. That's where you have to apply. I'm not going to dig into the different costs associated with filing the patent online. You can look that up on the same database. But let me tell you this. Getting an attorney is probably the best way to go if you're looking to file a patent. This process is extremely complicated. It is extremely lengthy. The average patent filing process and getting everything together can take anywhere from 6 to 8 months. Hang on one second here. Sorry about that. And so you want to be very strategic in which resources you're spending your money on, whether it's obtaining the patent or completing a prototype. Okay. The long story short, and when I said why no, can you create an invention without a patent? The answer is yes, you can. And the reason is, again, that they're two independent things. What you discover or what you invent doesn't necessarily need to be patented. You can. That gives you protection. But doing that also publicizes your idea. So think about the strategy of whether you want to follow Coca-Cola or not. For example, Coca-Cola, nobody knows what their secret ingredient is because they have not revealed it. They haven't got any patents on their unique formula because they want to keep that a secret. So what do? They create this invention or discovery, whatever you want to call it, and they treat it as a trade secret. So in this case, not having the patent keeps their secret with themselves. It's been a secret for hundreds of years, maybe not hundreds, but over 100 years. And at the same time, it is a proprietary formula. So instead of calling it a patent, you want to call it proprietary. All of a sudden, your invention, your discovery is protected, right? Nobody knows what it is. However, that doesn't stop you or stop others from creating that same product or service. So that's one of the things in terms of strategy you want to think about, whether you want to go obtain the patent, in which case it's publicized, right? However, it bars others from producing or mimicking this idea, and at the same time, it's not a cheap process. You can look at legal fees anywhere ranging from 10, 20, 30, 40, 50,000 easily based on the complexity of the case. It's a long process. It can take anywhere from 9 months to a few years in some cases. Or the other strategy is to keep all this in-house, keep it a secret, treat it like a trade secret, right? Which again is intellectual property, but at the same time doesn't bar others from copying your ideas, and you don't have a tool to particularly stop them. So that's the chicken or the egg that you want to think about. So publicize or protect, or publicize and protect. So short-term versus long-term, these are the considerations you want to have. The last question I want to take here before I have to jump off is from Sherry from New York, who has a question on copyrights. When I copyright a song and die, how long does my copyright last for? Well, that's a good question. Let me read you quickly what a copyright is, so it helps you understand what it is and how long it's for. So it's the 1976 Copyright Act I'm talking about here. This protects an author as soon as the work is recorded in some concrete way, since the act protects all expressions upon fixation in a tangible medium. So, Sherry, as long as you produce your song, right, so you go record it and you publish it even online or social media somewhere in some sort of permanent sort of form, it is automatically protected. Do you have to get a copyright by registering with the United States Copyright Office? By the way, the website for that is copyright.gov. Okay, so this particular body that regulates the copyrights is different from the Patents and Trademark Office. Okay, so slight difference there. Keep that in mind. And in this case, in terms of the copyright, Sherry, do you have to get the copyright registered? No, you don't. As I just read to you, it kicks in the moment you publish your content or your original content. But that said, can you sue someone for duplicating your work, infringing your rights and your copyrighted work? Well, this is where the registration part kicks in. To bring suit, you generally have to have a copyright law protection, right? So registered copyright. Now, this area can get very complicated. It's not something I can dig into today's particular show. However, I will check back with you next week with more about copyrights. I also have a few questions that I was not able to get to today. Excuse me. And here we're talking about a few questions for next week's show. Let me give you the topics really quick. We have Frank from Texas who says, as a small business owner of a cleaning company, do I need to have a lawyer on retainer for protection of my businesses and employees? A very valid question. I will give you the breakdown of what sort of contracts you need, what sort of areas you need to pay attention to when you have employees, and whether or not you need an attorney on retainer for this particular business you have. And we have another Sherry from New Jersey who says, starting a partnership with someone in the real estate company, should I use a lawyer to set up the corporation? Once again, corporate law is very complicated, even for practitioners who've been in the industry for decades. Every business, every situation is different. So the short and simple answer for your question is yes. These are complicated topics, especially in the real estate industry, highly regulated. So you want to be as careful as possible. It's probably prudent to have an attorney, but having said that, I'm not sure what the details of your particular case or question is, or if you have any specific risks or conflicts you have in mind. So if you can shed some more light into it, I'll be more than happy to dig into the details of it. Once again, if you like the details of the different websites I've talked about, the different resources I've put together, and the different questions here, make sure you jump on to my website, californialawservices.com, and go to the About Us or the Contact Us section so you can ask your particular question. I'll be more than happy to answer it. On the first page, as you dive in, you will notice a whole bunch of topics here that this cute cartoon guy has stemming out from his head. These are all the different topics that I hear on a day-to-day basis, and I'll be more than happy to help you answer some of these and get insights into these in your business. Once again, I thank you for being here. This is Entrepreneur Empowered. I'm Attorney Sid Pedinti. Thank you for spending the last 40 minutes with me. I hope I've answered some of the questions that Terry, Norma, and Sherry have had. And next week, we'll get to the other ones. For now, take care. Thanks for jumping on, and I will talk to you shortly.